Hello, my name is Joanne Ecob and I'm a barrister practising in family cases concerning children in both a domestic and international context. I'm a qualified arbitrator in children's cases and I'm currently the head of the Family Team International at 36 Family. The video you're watching is part of a 6-part series explaining the basic concepts of English law. I do invite you to watch the other parts of the series delivered by my colleagues in chambers. I'm going to start with when and how the courts of England and Wales have jurisdiction in children matters. Beginning then with the Hague 1996 Convention and the concept of habitual residence. England and Wales, like many other countries, has habitual residence as the founding principle in relation to its jurisdiction in children's cases in both domestic and international law. In international law, that is enshrined in the Hague Convention 1996. The meaning of habitual residence has been considered by the Supreme Court on a number of occasions since 2013. The test is that the place of habitual residence is the place which reflects some degree of integration by the child in a social and family environment. That will depend upon numerous factors, but the focus is on the actual situation of the child rather than on the purposes and intentions of a parent or other relevant adult. Remember that even as between two countries applying the same test, each country might argue for a different result. It's perfectly possible, for example, for England and, say, France, to both be claiming jurisdiction because each think that the child is habitually resident there. So there can be jurisdiction in more than one country because both countries applying the same test apply it differently and find that it applies in favour of themselves. England and Wales, in common with most other countries, have some other residual bases of jurisdiction, which includes habitual residence at the date of the application, even if the child has since moved to a non-Hague 96 country, so that Hague 96 doesn't apply, and becomes habitually resident there. The first of the residual bases of jurisdiction arises under Section 21B1 of the Family Law Act 1986 in connection with matrimonial proceedings. This is an unusual basis of jurisdiction based on matrimonial proceedings if 1996 Hague doesn't apply. So even if the child is not habitually resident in this country, England and Wales, if there have been matrimonial proceedings, in other words, a divorce or judicial separation in this country, any children issues related to those matrimonial proceedings will give rise to jurisdiction remaining in England as to the children issues. So, for example, where you have English expatriates living in a country where the children are habitually resident, but the divorce has taken place in England, and you can establish that the children dispute is related to the divorce, then the English court will have jurisdiction. Next, physical presence, mere physical presence in England and Wales is sufficient for the court to take urgent protective measures. There are two ways in which that can arise. First, under Article 11 of the 96 Hague Convention, where it applies. In any case where the child is physically present for however short a period of time in a state, and necessary measures of protection are required on an urgent basis, the court will have a limited jurisdiction to order such measures. Secondly, if Hague 96 does not apply, but if under the Family Law Act 1986, Section 23B2, the child is present in England and Wales on the relevant date and not habitually elsewhere in the UK, and the court considers the immediate exercise of its powers is necessary for the child's protection, jurisdiction will arise in England and Wales. Next, there is the inherent jurisdiction of the High Court of England and Wales. Circumstances in which the court can rely on its inherent jurisdiction are quite limited. It only applies where there's no other legal basis for establishing jurisdiction and where, in particular, the situation is not covered by the 1996 Hague Convention. The English High Court will be cautious before resorting to the use of the inherent jurisdiction for three main reasons. Firstly, the inherent jurisdiction may conflict with the jurisdictional scheme as between the two countries in question. Secondly, that might result in conflicting decisions in those countries. And thirdly, might result in unenforceable orders. Finally, there is an somewhat anachronistic jurisdiction known as parens patriae, which is based purely on nationality. And whilst it's true that lots of countries have a nationality-based jurisdiction, it may well only be England and Wales that has it based on the fact that the monarch is technically the parent of every child in the country. So we have a parens patriae jurisdiction because of the king's status. Every citizen owes the monarch a duty of loyalty, and because of that, the monarch owes every citizen a duty of protection. So, if a British national child is in danger anywhere in the world, then this jurisdiction can be claimed even though the child is habitually resident somewhere else. English children have been helped under this head of jurisdiction where they are at risk of, for example, female genital mutilation or forced marriage. There are a variety of situations in which children issues can arise. For example, following a family move to the UK, and there is a need for variation or enforcement of a previously made overseas order. A question might arise as to what enforcement in the UK would look like. There are a large range of orders that the English High Court and Family Court can make in respect of children. There's not time within this presentation to detail them all, but the following is a summary. Child arrangements orders under the Children Act 1989, Section 8, typically with which parent or other person a child should live, and when and how they should spend time with others, including the other parent. Prohibited steps orders, again under Section 8 of the Children Act, for example, not to remove the child from the jurisdiction of England and Wales. Specific issue orders, for example, allowing a parent to relocate abroad with a child, and if so, under what arrangements for the child to spend time with the left behind parent. Passport orders under the High Court's inherent jurisdiction. Public law orders, which is where the state, by means of local authorities, become involved and seek care or supervision orders under Section 31 of the Children Act 1989. Placement orders for adoption under the Adoption and Children Act 2002. Declarations of parentage under Section 55A of the Family Law Act 1986. Applications for parental orders where there has been a foreign surrogacy. And transfer of proceedings between jurisdictions pursuant to the 1996 Hague Convention, Articles 8 and 9. Moving on to abduction, the first port of call for us in the UK, where the issue is abduction, is via the UK's central authority known as ICACU, full name being International Child Abduction and Contact Unit, provided that the other country or countries concerned are also signatories to the 1980 Hague Convention. There will be situations, one, where a child has been wrongfully taken from the UK to another convention country, and their return to the UK is being sought, what is sometimes referred to as an outgoing application. And secondly, where a child has been wrongfully brought to the UK and their return to the other convention country is being sought, sometimes known as an incoming application. If a child has been wrongfully taken from the UK to another convention country, the first step for whoever is seeking the child's return to the UK will be to apply via the UK Central Authority, ICARCU, under the convention, which has the effect of instigating proceedings in the other state. And the courts of England and Wales are not generally involved. But the English court can also make a declaration of wrongful removal under the convention, which might be useful where the court in the other country needs assistance as to whether the removal was unlawful under English law. If a child has been brought to England and Wales from another convention country and you're acting for someone seeking the return of that child to, say, Spain or Ukraine, the first remedy will be to apply via the central authority in Spain or Ukraine under the convention. And that has the effect of instigating proceedings in England and Wales. That is where we at 36 Family can assist in terms of representation at any hearing in the English court. For the court in any convention country to make a return order, there must have been the following criteria satisfied. 1, a wrongful removal or retention within the meaning of Article 3. 2, proceedings must have been issued within a year. 3, none of the Article 13 exceptions apply. That is, A, consent by or acquiescence in the removal or retention by the applicant. B, grave risk of physical or psychological harm to the child if returned or return would otherwise place him or her in an intolerable situation. And C, the child, if of an appropriate age and maturity, objects to the return. Proceedings are essentially summary in nature, but there's a tension between that and the need to resolve disputed issues of fact fairly in relation, for example, to domestic abuse issues. There's a procedure to deal with such cases. Key is the consideration of what protective measures can be put in place to try and ensure that any return will be safe for the child on return. If the return is to be to the UK, we can advise as to what protective measures might be available in the UK and how those might be implemented. There will be some cases where Hague 1980 does not apply because the other state is not a ratified signatory to the 1980 Convention, but it is a signatory to the 1996 Hague Convention, an example being Morocco. And the 96 Convention can be used in such cases in response to abduction having occurred. If neither convention applies, the only option may be to seek a return order in the English court if jurisdiction can be established, which is likely to be in an abduction case, but the difficulty may well be one of enforcement in that other country. Which leads me to enforcement. Enforcement of children orders is a large topic and it's beyond the scope of this webinar. We at 36 Family can assist and advise as to enforcement. That is usually as to enforcement of overseas orders in England and Wales, but to an extent, at times, enforcement of English orders abroad, although that, of course, will often require specialist advice from a family lawyer in the other country. That's all I propose to say about enforcement, and in the next part, my colleague Marisa Allman is going to talk about surrogacy and adoption.